On July 20, 2005, Canada became the fourth country in the world, and the first country outside Europe, to legally recognize same-sex marriage nationwide with the enactment of the Civil Marriage Act, which provided a gender-neutral marriage definition. Court decisions, starting in 2003, had already legally recognized same-sex marriage in 8 out of 10 provinces and 1 of 3 territories, whose residents comprised about 90% of Canada's population. Before passage of the Act, more than 3,000 same-sex couples had already married in those areas. Most legal benefits commonly associated with marriage had been extended to cohabiting same-sex couples since 1999. The Civil Marriage Act was introduced by Prime Minister Paul Martin's Liberal minority government in the Canadian House of Commons on February 1, 2005 as Bill C-38. It was passed by the House of Commons on June 28, 2005, by the Senate on July 19, 2005, and it received royal assent the following day. Following the 2006 election, which was won by a Conservative minority government under new Prime Minister Stephen Harper, the House of Commons defeated a motion to reopen the matter by a vote of 175 to 123 on December 7, 2006, effectively reaffirming the legislation. This was the third vote supporting same-sex marriage taken by 3 parliaments under 3 prime ministers in 3 different years. As shown below, same-sex marriage by province. Same-sex marriage was legally recognized in the provinces and territories as of the following dates: June 10, 2003, Ontario; July 8, 2003, British Columbia; March 19, 2004, Quebec; July 14, 2004, Yukon; September 16, 2004, Manitoba; September 24, 2004, Nova Scotia; November 5, 2004, Saskatchewan; December 21, 2004, Newfoundland and Labrador; June 23, 2005, New Brunswick; July 20, 2005, Alberta, Prince Edward Island, Nunavut, and the Northwest Territories. Note that in some of these cases, the marriage was in fact legal at an earlier date, but the legality was questioned. As of the given dates, the legality was authoritatively established. The decision by the Ontario government to recognize the marriage that took place in Toronto, Ontario on January 14, 2001, retroactively makes Canada the first country in the world to have a government-legitimized same-sex marriage. Overview. Same-sex marriage was originally recognized at law as a result of cases in which courts in 8 out of 10 of Canada's provinces, and in 1 of its 3 territories, ruled existing bans on same-sex marriage unconstitutional. Thereafter, many same-sex couples obtained marriage licenses in those provinces, like opposite-sex couples. They did not need to be residents of any of those provinces to marry there. The legal status of same-sex marriages in these jurisdictions created an unusual jurisdictional issue. According to the Constitution of Canada, the definition of marriage is the exclusive responsibility of the federal government. This interpretation was upheld by a December 9, 2004 opinion of the Supreme Court of Canada. Until July 20, 2005, the federal government had not yet passed a law redefining marriage to conform to recent court decisions. Until the passage of Bill C-38, the previous definition of marriage remained binding in the 4 jurisdictions where courts had not yet ruled it unconstitutional, but void in the 9 jurisdictions where it had been successfully challenged before the courts. before the enactment of federal legislation recognizing same-sex marriage. Therefore, the application of federal marriage law differed depending on the province or territory. Given the Supreme Court ruling, the role of precedent in Canadian law, and the overall legal climate, it was very likely that any challenges to legalize same-sex marriage in the remaining 4 jurisdictions would be successful as well. Indeed, federal lawyers had ceased to contest such cases, and only Alberta's conservative provincial government remained officially opposed. Alberta Premier Ralph Klein threatened to invoke the notwithstanding clause of the Canadian Charter of Rights and Freedoms, which many law experts argued would not work. On June 17, 2003, Liberal Prime Minister Jean Chrétien announced that the government would present the bill, which would allow same-sex couples equal rights to marry. A draft of what would become Bill C-38 was released on July 17, 2003, by the Liberal Minister of Justice, Martin Corcoran. Before introducing it into Parliament, the federal cabinet submitted the bill as a reference to the Supreme Court, asking the court to rule on whether limiting marriage to heterosexual couples was consistent with the Canadian Charter of Rights and Freedoms, and, if same-sex civil unions are an acceptable alternative. On December 9, 2004, the Supreme Court of Canada ruled that the marriage of same-sex couples is constitutional, that the federal government has the sole authority to amend the definition of marriage, and the Charter's protection of freedom of religion grants religious institutions the right to refuse to perform the marriage ceremonies for same-sex couples. Following the Supreme Court's decision, Liberal Justice Minister Erwin Cotler introduced Bill C-38 on February 1, 2005, to legalize marriage between persons of the same sex across Canada. The Paul Martin government supported the bill but allowed a free vote by its backbench MPs in the House of Commons. Defeat of the bill in Parliament would have continued the status quo and probably incremental legalization, jurisdiction by jurisdiction, via court challenges. This trend could have been reversed only through Parliament passing a new law that explicitly restricted marriage to opposite-sex couples, notwithstanding the protection of equality rights afforded by the Canadian Charter of Rights and Freedoms, or by amending the Canadian Constitution, by inserting the clause "marriage is defined as being between a man and a woman," as was recommended by several conservative religious groups and politicians. Given the composition of the House of Commons at the time, such a measure would have been very unlikely to pass. Conservative Alberta Premier Ralph Klein proposed putting the question to the public at large via a national referendum, but his suggestion was rejected by all 4 party leaders.